everyone. This is Katerina Garavito with Rise, and we are very excited for our 2019 webinar series that we have a fabulous speaker today. For those of you who do not know Rise or are new to Rise, Rise stands for Rising Insurance Star Executives, which is an organization that's devoted to growing, recognizing, and advancing the best young professional talent in the insurance industry. We were founded in 2016, and we showcase the fun, innovative, and emerging aspects of the insurance field through our targeted networking events, interactive social media platforms, and technology-driven development webinars like today. We have Kate Browne here with us, who's a dear friend of mine that I met almost a year ago. And Kate Browne is an SVP at Swiss Re Insurance. She is an attorney who has spent her entire career in the insurance industry. She is a 1989 graduate of St. John's University of Law. Kate began her career at Mendes Mount and spent 2 years at AIG before joining Swiss Re in 2004. She's a member of the FDCC, DRI, and on the Rutgers University Big Data Advisory Board. She's written several papers on the legal implications of drones, autonomous vehicles, the Internet of Things, and other emerging risks. And today we have her speaking about why we sell insurance, and we're very excited to have her on. One quick note before I turn things over to Kate: for anyone that may have questions, please post them on the question part of the app, and we will address all of them at the end of the webinar. So to turn things over, Kate Browne.
Thank you, Katerina. And as Katerina mentioned, I have spent 30 years in insurance, and I have never, ever been bored. So one of the things we're going to do today is talk about some of the cases and some of the interesting things that people in insurance get to deal with. So we'll start off with just reminding everybody, one of the reasons we have to sell insurance is because, and I'm allowed to say this because I am a lawyer, lawyers are greedy people. And the United States has more lawyers and more lawsuits per capita than any other place in the world. And all kinds of things happen which lead us to have to sell insurance. So this is a real case that involved a tragic accident involving an Army lieutenant who was 23 years of age, and he was hit by a tractor trailer that had broken down in the left lane. And when his family sued the trucking company, one of the things they discovered was that the driver of the disabled tractor trailer had fixed a hole in the brake hose of the truck with a toothpick. That's what caused him to abruptly have to stop when the toothpick failed and Mr. Lieutenant Cordero smashed into the truck. So the jury awarded almost $18 million, including $15.5 million in punitive damages. And the purposes of punitive damages are to punish a defendant for willful or gross negligence. And certainly I don't think anyone would disagree that repairing a tractor trailer with a toothpick is an example of gross negligence. You have got to be nuts to use a blowtorch on a squirrel. This was a case that was filed by Travelers Insurance Company, and Travelers was forced to pay over $2 million to repair damages to an apartment complex, and the fire in the apartment complex was caused by Barbara Bellow's boyfriend, and Miss Bellow was asleep when her boyfriend took a blowtorch out on the deck of the apartment so that he could burn the fur off a squirrel. So yet another reason why you should always buy your homeowner's insurance, and a very exciting claim from the perspective of the homeowners insurers. Many people are familiar with the case involving Stella McCulloch from Texas, where McDonald's was held liable for serving her extremely hot coffee. But that is only the beginning, because now we have cases involving hot tequila. So the way we rate heat in food is on something called the Scoville scale. And the Scoville scale goes from between 2 Scovilles to 5 million. So a jalapeno pepper is about 10,000 on the Scoville scale. Pepper spray, which the police use, is between 2 and 5 million. And ghost pepper, which is what was allegedly placed in Mr. Bennett's tequila, ghost pepper is 1 million on the Scoville scale. So Bradley Bennett was drinking at a bar in Ohio when he claims he was served tequila that contained ghost peppers. And not only did he have extreme pain and suffering, but according to his complaint, every time he went to the bathroom, it was an excruciating experience. This guy is going to be a parent. This is another case involving a celebration. In this case, a diaper shootout to celebrate the birth of a baby. Apparently, when you have a diaper shootout in Ohio, the guests bring diapers to the new baby and enjoy an afternoon of shooting guns. In this case, they thought it would be fun if they blew up an old refrigerator. So they packed the refrigerator with explosives, stood about 50 meters away, and when the refrigerator blew up, it sent shrapnel flying across the yard, causing severe injury to one of the guests' hands. So if you are invited to a diaper shootout, please make sure that they have ample insurance. One of the things that when we work in insurance claims, you might hear people say is that God is great, there is good, and people are crazy. I think it's also the name of a country western song. And a good example of just how crazy people in Connecticut can get is in this lawsuit, which involved Mr. Rizzi. Mr. Rizzi had spent 6 hours in a gentleman's club drinking one afternoon, locked himself in the men's room, and when he emerged, he was completely naked. So the employees of the club tied his pants around his waist, wrapped his head in a shirt, and escorted him outside, where they left him to fall down an embankment and die. So it was a good thing that the bar involved had ample insurance coverage to pay the family's claim. One of the things that is always a lot of fun when you're doing a social event or a team building event is to consider Jello wrestling. And here is a nice ad. If you're interested in purchasing Jello for a Jello wrestling contest, it comes complete with pictures showing you how to use the Jello. But it also led to a very interesting lawsuit involving Avram Wazina. And Avram was a student at NYU here in Manhattan. And he was the resident advisor for his dorm student council. And he wanted to organize a beach bash to celebrate spring break. Now, here in New York, we do not have a lot of sandy beaches. So Avro decided he would improvise by having a Jello wrestling pool set up in the courtyard of the dormitory. So unfortunately for Avram, he was injured while wrestling in the Jello, and he filed a lawsuit. So one of the things that the law looks at is something we call assumption of risk, which says that if you participate in a sport or recreational activity, you're deemed to have assumed the normal risks that go along with this activity. So that's why if you're watching a baseball game, assumption of risk is the reason that you cannot sue if you get hit with the ball. So the question for the court was whether Jello wrestling is a sporting activity and whether Avra assumed the risks of being injured from Jello wrestling. And I'm happy to report that the court, in fact, ruled against Avram and said that yes, Jello wrestling was a sport and he assumed the risks associated with it. For anybody who's old enough to be a parent, please keep in mind a year at NYU is now about $67,000 a year. So when your kids don't answer the phone, you just assume they're in the library, okay? Firecrackers are always an interesting source of fascinating claims. In this case, it involves another college student, this one down in Marshall University, and he, Mr. Helmberg, was allegedly an innocent bystander when his fraternity brother, Travis, decided to launch a bottle rocket out of his anus while on the deck of the fraternity house at Marshall. Helmberg was so startled when he heard the firecracker go off that he jumped backwards, fell off the deck, and was so badly injured he was unable to continue to play for the Marshall University baseball team. And he also incurred significant medical expenses. So he argued that the fraternity should and the university should be strictly liable for his injuries because firing a bottle rocket out of one's anus is an ultra hazardous activity. And again, the court ruled in favor of against the college and actually in favor of the college and dismissed all the claims. And Mr. Helmberg was left to fend for himself. This is another case involving an interesting insurance coverage issue. Policies cause no end of litigation and interesting issues. In this case, a nonprofit corporation in Louisville that was dedicated to helping at-risk young people organized an outing to a concert, and at the end of the event, they didn't have enough vans to get all the kids home, so they had one of the members, Herbert Lee, drive 4 kids home in his car. Unfortunately for the nonprofit, Herb was 16 years old, had no license, and was driving a stolen car at the time of the incident. He killed 4 passengers. He was uninjured. So there were 2 policies at issue in this case. The primary policy excluded coverage for all auto claims, including any owned or operated by volunteer workers and club members. The excess policy had slightly different exclusions. It only excluded operations of an automobile. So the issue became what and who is a volunteer, and the company paid its limits because they were threatened with a bad suit claim against in the Sixth Circuit. So a very interesting coverage issue involving, unfortunately, very tragic facts. This is another fascinating case. In this case, David Woodhall and Chris Hamilton arrived at the same 4-way intersection, and Hamilton gave Woodhall the right of way, and Woodhall did not give Hamilton the customary thank you wave. So Hamilton follows Mr. Woodhall for 2 miles to a Circle K convenience store where he tells him that you have failed to give me the wave, and then pushes him into a rack of potato chips, breaking his elbow. So Woodhall sues Hamilton, and the insurance carrier denied the claim because the policy had an expected or intended exclusion that said if you expect or intend to cause an injury, we don't have to pay. So a lawsuit got filed, and it went to the Supreme Court of Indiana. And the trial court ruled that the insurance company had breached its duty to defend because when Hamilton pushed Woodhall, Hamilton was operating under the rage that he had been denied a thank you wave. And according to the court, when a Who's driver is deprived of a thank you wave, they are acting under self-defense because there has been an assault on the disrespected driver's sensibilities. So the court ruled against the insurance company and said that not getting a thank you wave was the equivalent of having your good manners assaulted. Not a great decision from the perspective of the insurance industry. So now that we've looked at some of the interesting issues that can happen with coverage lawsuits, one of the other things I get to do in my job is I have the best job in the company because I am Swiss Re's futurist. So this means I get to talk to underwriters about some of the interesting new technologies that we all have to deal with. And one of the big new risks that we have in our space is robots. So there are over 1 million robots operating worldwide right now, and we anticipate that it will only take us another 2 years to get to the next 1 million. And there are a lot of exciting legal issues around robots, including whether or not you can sue a robot. the European Union is considering a paper which is recommending that we create a registry for robots so that everyone who manufactures a robot or purchases a robot is required to register that robot so that we can track them down and we know where they are. And there have even been some legal papers written suggesting that robots ought to be considered the equivalent of a corporation, which would let them sue and be sued, and that robots could be considered the equivalent of virtual people. So anyone who is paying attention to the automated vehicle space knows that Elon Musk is doing some amazing things with Tesla. And one of the ways that Tesla has automated its assembly line is through the use of robots. But there have been significant delays in the production of the Tesla vehicles. And during the earnings call last year, Elon blamed the flufferbot. And according to Elon, we tried to automate the placement of fluff on battery packs. And they built a flufferbot, which he said was not real good at picking up pieces of fluff. It's a super complicated machine. And the line kept breaking down because Flufferbot would frequently just fail to pick up the fluff, or he would put it in the wrong location. So some clever person on Twitter put together a little tweet from the Flufferbot that said, "I can't believe Elon let me go. I thought I was doing a great job." We've already seen, unfortunately, some lawsuits involving bodily injury caused by robots. In this case, Mr. Chappell is a plaintiff, and he is working on the assembly line when, according to his lawsuit, the robot began to operate and placed a part down on Mr. Chappell's arm. When his coworkers tried to stop the robot, it did not release, and instead it began to increase the force it was putting on Mr. Chappell, and according to the complaint, crushing and grinding his body as it pulled it farther down the assembly line. So that is not a good thing. One of the other interesting things that came out in connection with a claim, and I'm not sure it relates to new technology so much, is a lawsuit where one of the witnesses claimed that she had had a psychic connect with the deceased and tell her that he had vigorously denied that the accident was his fault. And for anyone who is wondering what the difference between a medium and a psychic is, a psychic can connect with spirits, while mediums can read another person's energy. This case settled before it got to court, so we were never able to discover if, in fact, the judge would have allowed the testimony from the psychic or the medium about what the deceased spirit had to say about the cause of the accident. We've often had problems with people not getting policy language correct. So if you don't want to cover products, you should not put a products aggregate on your deck page. This is a case that's also out of Indiana. The policy had a exclusion for products completed operation hazards, and the deck page said there was a $2 million products completed operation aggregate limit. So not surprisingly, the court said you owe $2 million. A very similar case involving the Montana courts a couple months later. So if you take nothing else away from this webinar, please remember to make sure that your policy language matches up with your deck sheets. In case you thought that anyone actually read their insurance policy, this was a experiment that was done at a cafe in London. If you wanted to use the free Wi-Fi at the coffee shop, you had to agree to the terms and conditions. And the terms, which 6 people agreed to, including agreeing that in using the service, you are relinquishing your firstborn child. And in the event you didn't have any children, your most beloved pet would be taken. And the terms of the agreement stand for eternity. So in case you think anyone actually reads their insurance policy, this is a really good example of how few people actually read what they're supposed to. So I don't know if anyone has any questions. We finished a little earlier.
Thank you so much, Kate. That was so funny. Quick question on my end. Whatever happened with the disclaimer that you have to give up your first child? Was that a joke or?
No, it was an experiment. It was done by, university students got permission from the coffee shop to let them make that the disclaimer, and people
Oh,
agreed to it. So
that
it's
is hilarious. Oh my goodness. Okay, so we do have a few questions for you. Somebody asked, what would you say to young people who may feel that a career in insurance is boring or will be boring?
uh,
Obviously, you just spoke a lot
yeah,
about
I
it,
have to
but
tell you, I mean, I have two children, and I tell them both, insurance is the DNA of capitalism. Nothing happens without insurance, and it is such an exciting space to be in. I mean, I'm not sure we got all the slides in the right version, but one of the things we wanted to talk about, was just some of the new technology like virtual currencies, Bitcoins.
right.
Yeah, there were 1,600 different virtual currencies out there, and different governments define them as different things. Like in Germany, they are considered the equivalent of money. In Japan, they're not. In the Bank of England says they're an interesting technology. So we sell insurance policies, and all insurance policies cover cash, securities, currency. So, we as an industry now are talking to our stakeholders and talking, we're coming up with new policy language to make sure that we cover Bitcoins, because the governments globally define them differently. We want to offer protection for them. And one of the reasons why is, some of you might have heard about the fellow, it's not a good day at the office when you die. And there was $190 million in the Quadric exchange. It's a Canadian Bitcoin exchange. And it has $190 million worth of its customers' Bitcoins in what we call a hard wallet. And the CEO died, and no one can unlock his laptop. His wife says it's encrypted. Neither she nor anyone else knows the password. And he had sole responsibility for accessing the hard wallet, and he died while on safari in Africa. So right now, there's
What?
$190 million worth of Bitcoins that nobody can access. So it just,
Oh,
my God, right?
what do you do with that?
Yeah, well, that's
Is
just
that
it.
where?
The owners have filed a lawsuit in court in British Columbia demanding that somebody unencrypt his computer, and they've had all kinds of, specialists and hackers and try to be brought in to try to find a back door, to try to find some encryption key. They can't. So there's all sorts of lawsuits now being filed against the directors and officers of Quadric, against the company that designed the encryption software, because kind of like having the kill switch, or there ought to be a way to stop things when they start self-destructing. So think how exciting and fun that would be.
Yeah. No, I agree that insurance can be exciting, obviously, but we're trying to tell, especially as a hiring manager, which is actually another question. Um, should hiring managers be telling some of these stories to entice the interesting aspects of insurance?
Oh,
Is this
absolutely.
something that you think will
Yeah,
lure?
yeah, absolutely. We need to we have to correct the perception of the industry, especially if you watch The Incredibles and you saw Mr. Incredible as the claims guy sitting in his little
Yeah.
cubicle trying to
Yeah.
find this. That is not who, yes, we're all superheroes, obviously, in the insurance industry, but no, that is not what we do. That isn't even close to some of the opportunities and things people can do in the insurance space. Um,
Actually, I just watched Ocean's 8 the other
ah,
day,
there you
and
go.
they had the insurance guy in there, and I thought it was great, great luring that in there. Imagine insuring, what was it, $150 million of diamonds?
Right, the diamonds,
That's
yeah. And for
amazing.
people who are concerned, you might not know it, but insurance companies get one of the things you do when you're a futurist is you have to figure out what the next big products are going to be. So I look at the
Hmm.
patent office a lot. I get to go online and I get to see who's getting patents for all sorts of cool things. And the insurance industry, the number of patents that we have gotten has gone up 116% in the last 5 years. And the top three things the industry is getting patents for are apps, peer-to-peer, how do you
Hmm.
say, sharing economy, and automated vehicles. Being able to improve driver safety and hopefully give people better rates on car insurance by being able to personalize it. So it's
Right.
not your grandfather's insurance industry anymore. There's a lot of really exciting things happening in our space.
That line right there is, I think, very important. It's not your grandfather's insurance anymore. It's 2019. I think that this is our last question. And somebody asked, do you think you need or should have a legal degree to get into claims?
Oh, no, not at all. I mean, no, I mean, it depending on what you want to do. People who tend to like coverage issues tend to be lawyers, but it is absolutely not a prerequisite to be a lawyer. I think it helps. I have a kid in law school, but it's definitely not something that's required.
Okay.
And the nice thing about insurance, I've always thought, is that there's plenty of at least Swiss Re, it's easy to go. Claims people become underwriters, underwriters move into marketing. I don't think we have the same kind of silos that you find in, for instance, finance, where if you're a quant, you're a quant for the rest of your life. If you're in,
Right.
sale, if you're selling bonds, you sell bonds. I think there's a lot more opportunities to continually reinvent yourself in the insurance space, which prevents, boredom when you have to work. We used to be able to retire after 20 years. Now people have to work 30, 35 years. So if you're going to be in this space for this long, I think it's great that people have the opportunity to do so many different things.
So this is a personal question of mine. If someone's an underwriter right now or in claims right now, and maybe they've spent 5 years in either department, do you think it would be a wrong move to move into the opposite department? So to switch from claims to underwriting
Oh,
and
no, not
underwriting
at
to
all.
claims?
I mean, I don't know if I know a lot of companies do what we do. We have job rotations or Project Bumblebees, it's sometimes called, where
Mm.
you can go from place to place. What we do at Swiss Re is we have an internal site where people who need help, for instance, if we're going into a new line of insurance and we need people to help get us in that space, you can volunteer to go and do 2 months in sales, or you want to learn how to price the business. People who need help can post, hey, I'm trying to build a new model. Does anybody want to come and spend a couple months in actuary trying to help us figure this out? So I know we as a company are big supporters of the job rotation, bumblebeeing people around. Um, and from a personal, I think it's a great idea to get new skill sets in your existing job, especially if you're planning to move someplace else eventually, because it's harder to get on the job training now than it used to be. 20 years
Hmm.
ago, Affiliated FM or the Gallagher Bassett, some of the big adjusting houses actually had training programs where they taught people how to do certain things. It's harder to do that now. So I think getting that kind of experience on the job, and very few people are going to turn you down if you go to them and say, hey, I'm willing to take on, I have, my something else for a couple months. I think it's very unusual for someone to say, no, we don't want you.
That's a good point. Well, thank you again so much, Kate, for joining us and doing this for our members. And thank you for all of our members and listeners that are listening right now. Please look out for our upcoming webinars that we will be having in the next few months that we have on our website. If you have any additional questions, feel free to email us at hello@riseprofessionals.com, and we can get those questions to Kate Browne so that she can follow up with you either individually or through us. Well, thank you all and have a fabulous day.
Great. Thanks a lot, guys.
Bye.